Girl, you the bend, and she love me when I'm in it, and she never be pretending. Nothing is friend. She gon' tell you what she bought it, cause she know you can't afford it. Know you can get it, looking exquisite, no competition. Stay on the.
Hello, hello, hello. Welcome, everyone. You're watching the E Spot with Camille, and I'm your host, Camille Cower. And I cannot wait for you to meet my guest again today, Mr. John T. Rosenthal. He is the senior counsel in the Los Angeles office. I keep forgetting to find out how to pronounce it properly, but I think it's Kleindienst. He has a significant experience in representing clients in a wide variety of cases, but today we're going to talk to him about trademark laws, make sure we're all protecting ourselves with new incomes or new businesses we might have created during the pandemic. And he is here without further ado to answer all your questions. So if you have any, put them down in the comment and I will make sure to bring them up. Hi, John.
Hey,
How are you?
I'm good. How are you doing today, Camille?
I am doing fantastic. The weather is nice. There's not much new bad information coming out, thankfully. So I'm good. I'm good. You take the wins as you can get them. And I'm so glad that you're here with me today so we can talk about protecting ourselves from ending up in striped suits. Not that they really have prisons with striped suits anymore, but I figured I'd try a theme.
That's true. So I appreciate it. I'm glad to be back. I think as we talked earlier, last time we discussed copyright more than anything else. And so I
Right.
thought this time we talk about trademarks and what they represent, whether or not you need to apply for or register for a trademark,
Right.
and particularly in the context of some of the social movements that are going on right now as we speak, and whether or not you can actually get a trademark in something that you're participating in. So yeah, I can go right into it if you want me to.
No, let's start a little bit about just so they know why you're the expert at this and like you handle trademark law. Can you just share a little bit about what exactly or how long you've been working with trademarks so they have a little
Sure.
clue as to why they should listen to you for sure.
So I've been doing intellectual property law, which includes trademarks, copyrights, trade secrets, and things like that for almost 18 years now.
Okay, wow.
Um, yeah, I've handled clients who have worked in the infomercial industry, um, things involving some products involving the guy you guys maybe remember by the name of Billy Mays. One of the products was the Awesome Auger, but I've done copyright work. So things involving commercials, things involving products. Some of my clients um, uh, create wine products and they copyright their labels and they trademark the names that they use. Some of them are small distilleries who are just starting out and they want to get a trademark. I also have artist clients who copyright their work and then they want to start a business and they want to trademark a name for their business so that they can sell their art through that particular company. So those are the kinds of things I do
Nice.
with various clients.
Okay, wonderful. So yeah, let's get right into it then. What is the big difference between trademark versus copyright? Because I think a lot of people use it kind of interchangeable and they're not.
They're
So
absolutely not, and you're right, and they do often. So the copyright is your expression, your original expression of an idea, either the expressions on, paintbrush to canvas, pencil to paper, computer stylus to tablet. So, it's can be art, doesn't have to be art, but it can be the book, right? The actual words on a page. You
mhm.
copyright that because that's your original expression of your idea. You can't copyright the idea, the kind of intangible idea, but you can copyright the expression of it.
Okay.
Trademarks, on the other hand, are something very different. They are either a name, a symbol, a slogan that represents a particular category of goods or services. So it's the use of a symbol or a name to identify the particular business that is the source or origin of that goods or products. Good example, letters. IBM. Everybody knows that as International Business Machines, but they trademark the term IBM as the letters associated with their products or services. A symbol would be the Nike swoosh, for instance, okay? Or the McDonald's big golden arches. Um, you can also, believe it or not, trademark something called trade dress, okay? That is
Mm.
the shape of the product. For instance, everybody recognizes a Coke bottle right away because it's
Right.
got that kind of unique shape and those fluted design going down the bottle. You can
Hmm.
actually get protection for trade dress if that trade dress is what they call non-functional, meaning it's not part of the actual functioning of that particular product. Okay. You can also get trademarks in slogans. For example, Nike Just Do It. It's a slogan. Nike trademarked it, and now they can use it on their products or services. Okay. So those are kinds of examples of things you can get a trademark in versus, again, it's not the original expression of an idea. It's something that you want to associate that product with you, the maker of that product or service. So
Okay.
something that people assume that, oh, the trademark is for the company, right? It's the company's thing. Well, the
Hmm.
company might own it, but the real purpose of a trademark is to assure quality. Okay. So back in the day, we're talking over 100 years ago, people didn't always know where their things were coming from, who was making them. Okay. And you get by some bad meat or some bad soda pop or some bad whatever, you had no idea who to go to complain about it. Okay. Trademarks were ways for companies to say essentially, this product comes from us and we assure its quality. So, good example again, Nike, you pay a lot of money for Nike products, right? Why? Because there's associated
Market.
with marketing and quality, right?
Right.
Like,
Right. Yeah.
why am I going to pay a 30% premium for these, $100 and $200 Nike shoes if they're not in fact Nike shoes? Okay, so
Right.
again, it's really trademarks are really consumer oriented. You, the consumer, see the mark. Oh, I know that's Nike. Nike makes good stuff. That's why I'm going to pay a little extra for Nike. Okay.
Okay.
Um, the other thing about it is it forces the makers or the providers of those goods or services to take some kind of ownership over the control of the quality of what they're putting out.
Mhm.
McDonald's has a lot of franchises, right?
Right.
Not
Right.
they don't own all of their stores, but they, in order to continue to own that Golden Arches mark and that McDonald's trademark, they have to force their franchisors to exert some kind of quality control over what they do and what they make. Okay, if you don't do that, you can lose the trademark if you're not exerting some type of influence over the quality or control over the goods or services that are using that particular mark. Okay,
Got it.
consumer oriented. It ain't a you oriented thing, it's a consumer oriented thing. Okay,
Got it.
on the other hand, it's got the added benefit of, hey, they're associating that with this particular business and they'll pay more for that particular product because that business tends to put out high quality products. Okay,
Okay.
um, you can get a trademark. We call it a trademark, but you can also get it for services. Okay. Um,
Hmm.
People have heard of ServPro, probably, right? They clean up after accidents or spills or
Okay.
hurricanes or whatever. They don't provide they provide goods, but really their main thing is a service. But ServPro is their trademark. That's what is associated with the services they provide. You can think of tax preparers, right? They provide a service. They don't really provide goods, but they can get a service mark in that particular thing because it's associated with, again, a single producer, a single company, origin of that particular product.
Now,
Uh,
how does that work, I guess, for the art and entertainment world? If, for instance, actually somebody just put it in the comments, should singwriters register their copyright or music lyrics before recording, sharing a song, or is there a copyright asserted once they put pen to paper?
So
Oh,
as we talked
Debbie.
about last time, once you
Mhm.
put pen to paper, you own the copyright. Okay. The
Okay.
question is, how do you protect it? Okay. And as we talked about last time, you need to register it with the US Copyright Office once that song has been published. Meaning, once that song has gone to a publisher, it's been put on paper, and people can start purchasing it. Okay.
Mhm.
There's a whole different group of laws about actual somebody performing it, okay, as
Mhm.
opposed to putting it on paper and selling it, okay. But in order to protect it, you need to register it. And I think we talked about last time, you can also register it as an unpublished work. And then once you publish it, contact the Copyright Office about it now being a published work. But that's definitely something you need to do. Trademarks, kind of the same way, although unlike copyright, once you start using a trademark in commerce, you have a certain level of protection, even if you don't register it with the U.S. Patent and Trademark Office. Okay, and we'll go into that a little bit. There's something that people confuse. People talk about brands a lot. Okay, I want to brand something, and then
Sure.
they think that a brand is a trademark. They're not really interchangeable. Okay, again, a trademark tells consumers that particular good or product comes from a single source. It doesn't tell you where necessarily what the source is, nor does it have to. Okay, you'll find out probably, but you can use, for instance, trade name, which you might want to brand versus trademark. Kimberly Clark is the name of a company. Okay, probably I'm not sure if anybody's even knows who it is or even heard of them. Okay, that's the name of the company. It's not necessarily a trademark, but guess what they make? They make Huggies. Everybody's heard of Huggies, right? Huggies is a trademarked product. They registered the name of that product with the U.S. Patent and Trademark Office. So is the Huggies branded? I don't know. I guess so, but it's trademarked. Kimberly Clark, on the other hand, the company doesn't necessarily need to trademark their name. They might not even be able to get a trademark in their name. Okay, people
Mhm.
associate Huggies with diapers and that it's made by a single source, whether or not they know the name of Kimberly Clark or not. Okay, so, you know, branding is not interchangeable with trademark. Trademark isn't interchangeable with trade name, and they're definitely not interchangeable with copyright, if that makes any sense.
Yeah, no, I mean, I think just from my standpoint, a lot of times you hear, "Oh, I'm creating a brand. I'm the brand. You're the brand." You hear it so frequently, just kind of not really understanding that there's the legal side to the brand that you need to be protective of too.
It's true. So, you as an individual, you know, are you a brand? You might be, okay, but does Camille need to trademark her name? I'm not sure you have to. I'm not even sure you can in some instances, okay? You could still be the brand. You're doing this show, right? People know of you from this show. That could be a brand, okay?
Right.
It'd be different if Camille decides to go into, say, beauty products or say consulting for, blogging or consulting for shows. At that point, yeah, you might want to, take consulting by Camille and turn that into a trademark and register it. But that's it's a subset of your brand, right? This shows your brand.
Now,
Are
what
your brand.
protections would that even? I mean, like, why would somebody need that kind of protection on their name? Or like for me, I'm just like, oh, that's just more money to spend. Do I need this kind of? Do you need to trademark your name or not your name, but like maybe your
It,
business services if you're not to the point of Nike and Coca-Cola?
it depends. Okay, so as I said before, you as soon as you start a company and start selling things or services in commerce, okay, meaning you're actually somebody's contracting for you to do something, you're selling them something, the mark is being used on either the advertising or the product itself. Okay, you may
Mhm.
want to trademark your name. Now you have what's called common law rights in that trademark without having registered anything, meaning just by use. The question is, how strong are those rights to that mark? If you haven't registered, they generally tend to be less strong. Okay, if you're only selling in, say, Los Angeles, then The strength of your trademark is not going to penetrate New York, probably, okay? But you may want to. The question is, can you get one? Okay, so a couple of things. First, you're not going to get a trademark for what's called a generic name or a generic mark. Okay, so you create tomato soup and you want to call your product tomato soup and you try to register that with the US Patent and Trademark Office, they're not going to give you that, okay?
Right.
Because
Yeah.
it's a generic mark. It describes everything that's in this tomato soup category, okay? You could also consider it to be a descriptive mark. They're probably not going to give you a trademark in a descriptive mark. You have a product called running shoes, which actually happen to be running shoes. It describes the good that you're selling. They're not going to give you a trademark. Trademarks generally require the consumer to make a leap of imagination, okay, from the mark to the good, okay, or the service. Um, so, for instance, Nike, I think I can't remember, it's the god of war or Mars is the god of war, okay? I think Nike's was one of the sub gods, whatever. You don't associate that with running shoes, right?
No. Right.
So that takes a leap of imagination for you to go, oh, the swoosh, running shoes. Oh, okay, I get that now. But you wouldn't get it right off the bat. Um, and that's the kind of thing that's called a either a fanciful or arbitrary mark, okay, or a suggestive mark. The Patent and Trademark Office will give you a trademark if your mark is arbitrary, fanciful, okay, can't connect the product or the services right away to the mark. It doesn't describe the thing,
Okay.
or it's suggestive, okay?
I think
Um,
that also like there was I don't remember if you heard about this. There was like a restaurant, maybe it was in Chicago, it was somewhere mainland, and they wanted to copyright either Poke or Aloha. It was one or the other because it was in the name of their restaurant and they were serving poke bowls and so on, or pokey.
Pokey,
Now
right.
yeah, pokey. I'm like, wait, that's not right. Facebook, they poke. So I got confusing
They
the two.
probably couldn't if it describes the service or product that they're
Right.
making, like poke bowls, and that's what you sell.
Hmm.
Probably not. On the other hand, Aloha doesn't necessarily go right away to like Hawaiian food. Okay, so could you name your restaurant, Aloha Waves? Yeah, because it doesn't. Aloha Waves don't describe the product or good or service that you're providing, right? It
Right.
says suggests something else. I'll give you an example. Arbitrary mark. Okay, Krusty's, which is does pie stuff. Okay, by
Okay.
Kraft. Okay, that doesn't tell you right away that that particular good or service is pie making stuff, right?
Right. Right.
Another one, Sunmade for raisins, right? Sunmade,
Mhm.
what does that have to do with raisins? Those are
Mm.
the kind of marks that are fanciful, arbitrary, okay? Sometimes they will give you things that are what are called suggestive. So it kind of suggests the thing, like maybe Aloha Wave suggests Hawaii, right? But it doesn't really
Right.
tell you, hey, I'm making poke bowls with tuna and rice. So those are the kinds of things. You're not going to get one, again, in something that's descriptive, although you could do what's called put it down on the supplemental registry. That's a whole nother layer of law. But
Mhm.
generally, generic marks and descriptive marks, you're not going to get a trademark. Suggestive and arbitrary, you are. So, how do you get these kind of rights? Okay, again, you have to actually sell the stuff in commerce. I have a lot of people approach me. Oh, I got this great idea. I want to trademark this thing. Okay, and I want to call it X. And I'm like, cool. How many of X have you sold? I have none. I don't even have a manufacturer yet.
Mm.
Okay, so guess what? You're not getting a trademark in that because you haven't sold any, you haven't advertised any, you haven't made any. Okay,
And I would assume that it would be the other way around, like before you put it out there so other people would know the name that you would trademark it, but that's not the case. You have to already have been selling the items or maybe the t-shirt with the slogan or whatever. And then,
generally, okay, you're
okay,
right. You
okay.
would think it was flip flopped, okay, but
Mhm.
for the longest time, the Patent and Trademark Office was no, a trademark's associated with consumers identifying that good or product with a single source, and if you're not selling any, how can they identify it with anything? Now, a couple years ago, the Congress enacted a law, they changed the statute, and now you can file something called an intent to use trademark, which does exactly what you were talking about.
Okay.
Okay. So you basically say, hey, I don't want to spend a ton of money yet on a trademark or a brand before I even know who's going to make it, how I'm going to make it, or whatever. So you apply for the trademark with the U.S. Patent and Trademark Office on what's called an intent to use basis. You tell them, listen, I'm planning on using Camille for eyelash liner or Camille for apparel. I don't have anything yet, but I'm going to. And as long as that doesn't conflict with other marks that are already out there, they will grant you a registration on what's called an intent to use basis.
Okay.
6 months later, you have to file with the Patent and Trademark Office an actual sample of what you're selling using that mark. So you can say, hey, I told you I was going to use this. Now I'm using it. So you
Okay.
can get an intent to use, but again, it all comes back to the trademark office at some point is going to say, I need to see a sample of what you're actually using this mark on that matches what you told me you were going to use it for. So yeah, you can kind of flip it a little bit, but ultimately it comes back to, Camille, have I sold any of this stuff in commerce so that consumers recognize it's coming from a single source or associated with the single source. That's what trademark's all about. Think about trademark, it's consumer protection. It's not really company protection, although a lot of companies use it that way. I think we were talking about a couple other things. You mentioned names. Okay.
Yeah, this is the fun part with like
Right.
the Kardashians and all of them. They have like 400 trademarks, some of them including their, or at least processed or have applied for 400 or more. And Kanye West, I think, also had like 400 individually as well. But they have their children, like every version of eyeshadow, makeups, or anything with the K in front of it instead. So it's K shadow or K
Right.
lip liner or whatever.
I remember
Yeah.
you were talking about this. I think one of their children has, applied for trademark. Clearly, the child didn't apply for it, but the parent did. So I went and looked some of that stuff up.
Okay.
And the children's marks are intent to use marks because they haven't made anything yet. Okay.
Right.
But they're basically, I think you and I talked about it, they're trying to stop other people from capitalizing on their kids' names inappropriately. Okay. Or what they would think is inappropriately. Now, you can't always get a trademark in somebody's name. Okay. First of all, if it's a living person, you actually have to get written consent of that person. So if I want to go trademark your name, I probably can't unless you give me written consent and I file that with the trademark office. However, you being you probably could register your name with the trademark office for, again, apparel, consulting, business, something like that. Okay. If you actually use the mark and it doesn't conflict with somebody else's mark. Okay. And
And
again,
they can't consent because they're not 18, or they just can't consent because
no, they can.
okay.
It's basically, are they consenting? They're a live person. Are they
Mhm.
18 yet? I'm not even aware of those type of laws if they're an adult and
Okay.
have to consent. But probably they have their parents' consent or they have their consent, and so they file it with the trademark office. But right now, their kids' names are intent to use basis trademarks. They're not selling anything. They're not selling any, you know, uh, um,
Baby gap.
baby gap or anything like that. Okay, they're intent to use only. Um, you one of the so you can get names of living people. You need their consent. Sometimes the trademark office frowns on that. Okay, um, oftentimes you can't get geographical locations if that's where your product is from. Okay, give you an
So
example.
Northwest.
Northwest. Now that one was so generic. You might, right, northwest of what? But
Mm.
there was a small distillery in Kentucky. They wanted to have their name Boone County Distilling. The distillery's in Boone County. Trademark office said, we're not doing that because all you're doing is associating your distillery with a county that you're in, not with a product or a service. So they
Okay.
declined that. Okay. But I also know a couple others
I
because
was
I
gonna say,
helped
did
them
they
out.
become Boone's Farm?
What's that? They didn't go Boone's Farm, but they still use the name. Okay, don't they still
Okay.
have the name? but they didn't get it registered with the trademark office, the federal trademark office. But another small distiller called Balcones in Texas, they got theirs. They're a very good distillery. They make a phenomenal whiskey. What's interesting, though, is Balcones also happens to be a geographic location, the Balcones Fault in Texas. And I don't know if the trademark examiner knew that, because guess where their distillery is? Right near the Balcones Fault in Texas, which I'll guarantee you is why they named it that. But
Right.
the examiner maybe didn't take a second look at what was going on there. It's like, hey, balconies has nothing to do with whiskey. Fine, you got the mark. Couple other generic things, and I'll get into Black Lives Matter because I think that's what interests people. Trademarks last for 10 years. Once you register originally, with between year 5 and 6, you have to file an actual use statement with the trademark office. So one of the things that gets my clients into trouble is, oh yeah, I got this great idea, got this trademark, I sold 25 shirts, and now I haven't used it again in 5 years. Guess what? You don't get that trademark. You don't get to keep it. You need to continuously use it, and you need to continuously use it in a substantial way. Selling 5 t-shirts is not substantial. Sending, sample perfume to your grandmother is not in commerce use. Okay, you have to actually be selling the stuff, advertising the stuff over that entire period of time without any major breaks to be able to keep the mark. So interesting. Black Lives Matter. I thought I'd get into this because I thought it was interesting. So you have these social demonstrations, social protests, and people are wearing T-shirts all over the place, right? Black Lives Matters,
It's
cool
on
design,
everything. Yeah.
on everything, right? And I'm like, wonder if anybody's applied for that mark. So right now, there are in excess of 30 trademark applications for Black Lives Matters. And even before that, there were a couple of applications that got denied. Now, why were these things getting denied, and why are most of these trademarks going to get denied? Because the trademark Black Lives Matter isn't associated with any of the products that these people say they're going to make, right? I'm going to put it on a t-shirt. You put it on a black t-shirt in white letters, is anybody associating that trait, that slogan, with a single manufacturer or producer?
Right. Got it.
No, they're not, right? They're
Yeah.
like, man, I see these things in Portland. I see them in DC. I see them in Florida. I don't know who's making this stuff. So the trademark office basically, when the first ones were applied for, actually back in 2016, they essentially said, this is a political movement. It has no association with the single manufacturer. Your mark is denied. Okay. And that's likely what's going to happen with the rest of these trademarks.
Now, could the
Again,
women that created the Black Lives Matter movement, could they have had it trademarked?
they might have been able to if they used it associated with some sort of consulting. The problem is, again, and this is, I'll give you another example of a company that didn't protect its brand or its name, and now it's generic. Thermos. Thermos used to be a name for a trademark name for a particular product, right, that kept things hot and cold.
Right.
Thermos came out with that. Everybody started calling their similar container to keep things hot and cold a thermos. And at some point, the trademark office said, we're not granting you a trademark in that anymore because everybody associates thermos with just a thing that keeps liquids hot and cold.
Yeah.
So they lost their protection for that trademark. Black Lives Matter, the 3 women that started that term, they haven't protected that mark. It's 4 or 5 years later. All sorts of people are using it. I doubt they could get protection for it. An example of a manufacturer not letting that happen, Kleenex.
That's what I was wondering.
So Kleenex comes out,
When you
right?
said thermos, I was like, ooh, I wonder about Kleenex. Yeah. Okay.
Kleenex comes out. So if it's actually a Kleenex product, they use Kleenex. What does everybody else use?
Tissue. Bathroom
Facial
tissue.
tissue, right?
Okay.
Because Kleenex said, hey, well, we're not letting happen to us what happened to Thermos. You use our mark, we're going to sue you. End of story. Okay.
Or even like Xerox. You remember? People used to use that all the time.
And Xerox almost became generic. Okay.
Huh.
But the best example is Thermos. The
Okay.
trademark office is not going to let you sit on your hands and not protect your trademark so that it becomes associated generically with the product, and then boom. But I'll give you another couple of examples. I was looking up a company that did get a trademark associated with Black Lives Matter is, interestingly enough, a lawyer in Boston got issued intent to use trademarks for Black Lives Matter to and Black Lives Matter to me. A guy named, which is a little bit odd. What was his name? I'll get it to you here. I can't find it now. By the last name of Zevez.
Hmm.
So I don't know. He's a lawyer in Boston. He's associated with the law firm. He basically went to the Patent and Trademark Office and argued, by the addition of the word to me or to, that separates it from the other use. I will tell you this. A lot of times when you use some trademarks, you will have to disclaim parts of it. So if
Mm-hmm.
you have, for instance, I have a client, they use the mark Museum Nerd, okay? They're probably not going to get to have exclusive rights to the word museum, right? But
Right.
so the trademark office will make them disclaim that very like average word, but they will still get rights to those two words together. Okay. So
Okay.
those two words together, that will get them protection. Using the word museum, you can't sue anybody over that. I will tell you, there was one other interesting thing I found was, Black Lives Matter. Somebody applied for Black Lives Matter for hand sanitizers. They haven't gotten the mark yet, but it's still there. Another person applied for it, Black Lives Matter Moscato, which I thought
Oh.
was kind of interesting, under the name Strange Fruit. I'm not sure that was going to be a big seller, but people have applied for it.
I don't think I want to
Um,
drink. I mean, I don't drink anyway, but that would be less appealing to me.
yeah, that's. I thought that was an interesting mark. The other
Especially with
mark that's
what strange fruit means. So,
Yeah, the other
hmm.
mark that's what I thought. Strange fruit. That's probably something I would stay away from in terms of consumer products, but they applied for it.
Wow.
One of the other marks you and I were talking about, the George Floyd Foundation. So
Hmm.
George Floyd's brother, Phileas, I think, Floyd, applied for the George Floyd Foundation trademark on June 12th, 2020. Mr. Floyd, unfortunately, was murdered on May 25th, 2020, and he's applying for the mark for use in essentially consulting and foundation work and things like that. Thought that was kind of interesting that somebody in his family would apply for that mark. So those are kind of trademarks, up and coming stuff. Another example before we get off, everybody
Yeah.
likes this slogan stuff, right?
Right.
So you put a big slogan on the front of a T-shirt, Black Lives Matter, BLM. I saw people trying to get that, okay,
Okay.
and then say, "Hey, I've used it in commerce." No, you haven't. All you've done is put a slogan as an ornament on the front of a T-shirt. Nobody associates that with your company. Trademarks, again, are associated with companies, so consumers can say, "Oh, that's where it came from." You want to create a trademark for a T-shirt, you need to put that brand or that trademark on the tag, the label inside, on the hang tag, on the product packaging, so that it looks like this is being used like a trademark. It's not just being used like an ornament across somebody's chest on a T-shirt or in big letters across a mug or on a sticker, okay? That's not trademark use. That's just ornamentation, and the trademark office really won't accept that as trademark use. So I know I've talked too much. Got any
No, no problem.
questions?
Yeah.
Anything that I didn't cover or you think people might be interested in?
No, I remember when we were talking off air, even for all these like influencers and so on, even protecting themselves online, as far as we were talking about branding and like if they got free products to make sure they mention that and so on, like how to protect themselves even on that side of it. Because a
Yeah,
lot of people now are, myself included, are becoming part of that side of the world of wanting to wanted to make sure we're doing it legally so we don't get sued.
And I'll
So,
tell you what, this will be a teaser for our next one. But brand influencers have to be very careful, because when you are promoting a product, even if it's on Instagram, even if it's on Facebook, and the producer of that product is either paying you to do so or giving you product, whether free or at a discount, you have to disclose that to the public, because the public has a right to know of whether or not you've now become an endorser for that product by virtue of the producer influencing how you talk about it. So, the Trademark Commission, the Federal Trademark Commission, the FTC, actually come out with rules, particularly for influencers, about disclosures that are required for them, when they are hawking products or pitching products, of companies that are actually giving them free products. So
right.
be very careful. Even though it's the internet, there are regulations that apply, and it's no longer kind of the Wild West anymore.
No, for sure. My cousin just brought up a great question with the whole Lady Annabella matter. I'm not sure if you're familiar, but what about the Lady Annabella matter? How can underfunded creatives protect themselves and their identity / marketing materials? Are you familiar with that?
So it really depends. So antebellum, okay, is a generic description of a period of time in U.S. history. Okay, so could you get a trademark in antebellum?
Well, okay,
Go ahead.
Lady Annabella, they decided to change their name to Lady A, but there already is an established singer, a Black woman actually, whose name is Lady A. But because of
Oh, okay.
the Confederate matter with Annabellum, they wanted to change their name because it's like a group and it's not just one lady in the group
Right.
matter too. But they're changing it and they're now like kind of fighting the woman on her name because they're more famous than her, I guess.
So it depends on whether or not they trademark it. It depends on what they're associated with. Okay. Usually, trademark is first in line, first in time, has the rights to the mark. Okay. Unless you were using Lady Antebellum on, perfume, and they're using Lady Antebellum on car products. Okay. Generally, people don't associate those two things together, right?
Right. Since they're
Um,
both performers, Lady
but
A.
yeah,
Yeah.
if they're both performers. Now the question is, can they get a
Oh, wait,
trademark
there's
in it?
more. Country Group already has a trademark on Lady A.
There you go. So if they have a Lady A trademark, probably somebody else can't use Lady A, okay,
Mm.
to do songs unless that's your name. Okay, so somebody can't stop you from using your name.
Mm.
Okay, unless you use your name as a trademark. For instance, believe it or not, we had a very famous client. I won't mention the clothing manufacturer. The famous client was a relative of a very famous clothing manufacturing company. That client was using their name, and the clothing manufacturer tried to sue them and stop them from using it. Okay.
Mhm.
Initially, the court said, now we're not going to stop you from using your name. But as soon as that person started using letters associated with that name, in a way that was very similar to the clothing manufacturer that used letters associated with that name, court said, no, no, not anymore. You're not using it as your name. Now you're using it like a trademark, and you got to stop.
Okay.
So yeah, Lady A, it's first in line, first in time. I see that she's used it for 20 years, but the question is, how did she use it? How famous was she? What was the material she used? And there could be a fight about it. The other thing about trademark infringement is, can you really afford to fight somebody about it? Particularly if
Yeah.
they're a big company, even if you're first in line, first in time. It really depends.
Mm. Poor lady. I feel bad for her because she's been using the name for, like they mentioned, for over 20 years, but without a trademark.
So again, she may own what are called common law rights in that without
Mhm.
a registration. Okay. The question will be, is her mark strong or weak? How much is she sold, not sold? How much do people associate that with her? Okay, her songwriting, her songs or whatever, as opposed to somebody else. Okay, that kind of is what it depends on. Once you start using a mark consistently in commerce, you have common law rights in that, but the question is how weak or how strong are they? When you register with the Federal Trademark Office, one of the things that you get help with is, okay, now you have federal legal protections, and once you've been selling it in commerce for 5 years and you file that statement of use, okay, then it's assumed that it's a strong mark. Whereas if you don't file, they basically you have to show it's a trademark at all. So it's a very different level of proof that gets involved once you've registered with the Federal Trademark Office.
Well, good luck to them, because I know Lady Antebellum, they've won some awards, so I'm pretty sure they have a stronger.
They
Uh,
do, except they
yeah,
weren't using the word Lady A,
oh,
right?
they were. Oh
Yeah,
well,
that
somebody was saying that they had already trademarked Lady A, so maybe they had as a
maybe they
shorthand.
had, or maybe they, but it kind of depends. Again, first in line, first in time generally gets use, but it really depends on what type of use, how strong the use, sales, marketing materials, how long, what your audience is, and have you really been using it as a trademark as opposed to some kind of a name affiliation for you.
Mm,
So,
freak, yeah. All because they finally got a conscience over their name, and
yeah,
now she's got to think of a new one. I'm sure she'll come up with something even better and greater, and all the publicity around her name now might even help.
it could be. Absolutely.
Oh wow. Well, just if there's anyone else with questions, real quick, you got about 5 minutes to put them in. Well, maybe not 5 minutes, but a few more minutes to put them in. Now I'm curious, with everything else going on, I know I see a lot of times with people will post these comments, or not so much comments, but they'll post about, if I write this, then Facebook can't use my images without my permission, or this, that, and the other. How much do they really own once you put your images on Instagram or Facebook, or your any type of content that you made yourself, or pictures or so on? Is that
So,
really true?
yeah, so you, once again, for copyright purposes, once you put pen to paper, you own the copyright. Okay. The question is about protection. And even if you post it online, you still own the copyright. You don't lose the copyright. Okay.
Right.
I have clients who are graffiti artists. Okay. And one of the things that people always think is, oh, it's graffiti, so I can use it. Anybody can use it. It's in the public. Not
Mhm.
true. Particularly not true if you're trying to commercialize it. Okay. So I always tell my graffiti artists, listen, you painted this tremendous mural. Okay. We need to copyright it so you protect it. So let's take some pictures of it, and you're going to put those pictures on postcards or on your Instagram, and you're going to advertise that you're selling products or goods that will replicate that incredible mural,
Mhm.
so that we can then register it with the Copyright Office. Um, Graffiti is kind of quirky, but yeah, that's basically what you do. And again, like we were talking about in the last session, if you post your original work on Instagram, okay, or on Facebook, or whatever social media, it's essential that you put some kind of tag on it, identifying it as yours.
Okay.
Great example is, I have a graffiti artist out here in LA. He puts his Instagram name on every mural he does, someplace, which
Okay.
identifies him as the creator. And
Mhm.
again, we were talking about it, this law called the Digital Millennium Copyright Act. As soon as you put down something on your original work that identifies you as the owner or the creator, somebody else uses it and cuts that thing off, they violated that law. Okay, that's the whole point of that law.
Yeah.
So you don't lose it when you put your original content on Instagram. The question is, how much can you protect it, and what can you do to protect it? And again, put your identifying information on your work someplace.
Okay. Watermarks, watermarks, watermarks.
Yep,
On
something.
top of it. Yeah,
Watermarks,
somewhere.
whatever it is. You know what I mean?
No kidding. And so in the comments, they're like, always file those statements. Very important, from another attorney, Nicole Gatewood.
Absolutely.
So
Nicole's spot on. You don't file the statement of use between year 5 and year 6, you lose the trademark, okay, and you lose the protection. But again, you got to be using it, okay? Slogans. I wanted to go over this Black Lives Matter and the slogans thing before we get off the air. So you can trademark slogans, okay? But again, the question is the slogan associated with a single original producer of either that good or that service? So, you put Black Lives Matter on a t-shirt and sell 50 t-shirts outside of Staples Center in LA, no one associates that with you, okay? But super smart businessman. I don't know if people are familiar with a guy named Marshawn Lynch. Used to play
yes,
running back. Yep,
yeah.
beast mode. You and I talked about it, right?
Yeah,
Even
yeah.
non-sports people, beast mode likes. What was it? It was he had a particular kind of candy he liked. I can't think of the name of it. Skittles. I think he loves Skittles. Yeah. He's also a very smart businessman. So at one point, there was a requirement by the commissioner of football that during the Super Bowl, some of these stars had to sit down and have press conferences and answer questions. So Marshawn Lynch has never been a fan of answering a lot of questions by the press. It's just not his thing. Okay. But the commissioner said, you don't sit for a press interview during the time allotted, you're going to get fined. So Marshawn Lynch shows up at his press conference, and reporters start asking him questions, and his response is, I'm just here so I don't get fined. People love that, right?
Right.
And he realizes people love that. He applied for that slogan with the Patent and Trademark Office and actually got it for t-shirts, hats, stuff like that. Now, why did he get it and other people don't get, trademarks for their slogans? Because it became associated with Marshawn Lynch, and he immediately jumped on it and started making t-shirts using that slogan, oftentimes with his image on it, but not always. Okay.
It makes me also think of Paris Hilton with That's Hot, because she got that trademarked.
There you go. If
Yeah.
you kind of jump on it, okay, and actually use it, and it's associated with you, with not just you, but the single producer of those products, you can get a trademark for a slogan. I'll tell you another example, and then I know we got to go. Allen Iverson once had a famous press conference in which the press were like asking him all these questions about not showing up for practice one time. And he basically said, we're talking about practice, not a game, not the playoffs. We're talking about practice. And that got super famous. Okay. Some guy actually tried to trademark, we're talking about practice, okay, for, I think it was t-shirts. No, didn't give it to him. Why? Because it's not associated with him, okay, at all. Um, Generally, if you hear some slogan by some star and you try to commercialize it and it has nothing to do with you, odds are probably not going to get a trademark for that slogan. Not always, but generally, you're not going to get it, okay? Because it's not associated with you. It's not associated with you as the maker or producer of that particular good or service.
Now, how
So
does that work even for like actors? I'm thinking about like if they portrayed a role and within that role, a line they said in the movie becomes famous and people are start saying it, could they trademark it in that
here's
way
the
too?
thing. Question is probably not, okay?
Okay.
Why?
Because they write it.
Because the writer, the person who put that thing pen to paper, they own the copyright to that slogan. You can't generally copyright slogans, believe it or not. You can trademark them, but you can't copyright them, okay? Usually. So, yeah, they're not, that particular slogan, even though it's associated with that actor, the guy who, or the woman who wrote the screenplay, or the company that owns the screenplay, right? They're the owner of the copyright to that. Probably not going to allow the actor to assume the trademark ownership for that particular slogan. But I'm sure it's complicated because maybe the actors have some carve out in their agreement that says, if some particular thing becomes associated with me and with my performance in there, I get the rights to it. Don't know, but I could see that happening.
Okay, kind of on that same note where you were talking about with George Floyd's family and the foundation,
Hmm.
Goldie Bell's asking, can you put the names of the people that were murdered on a shirt to sell? The plan is to use the funds to donate to families who lost someone to police brutality.
So I hear this basically Good Samaritan excuse for
Mm,
using things, and the response is probably not.
okay.
Those names of those dead people, God bless them, are not associated with you or with you as a single producer. Okay. Now,
Mm,
could you put their names on a T-shirt, sell the T-shirts, and give the money to foundations that support those individuals? Absolutely. Okay. Absolutely, in the sense that you can do that. Now, will some of their family members object to that? Maybe as you
mm,
commercializing a dead person's name for your partial benefit, I could see people having a real problem with that, right? But
right.
the notion that you would get a trademark in putting the names of deceased people on a T-shirt and selling it, again, it's almost analogous to Black Lives Matter. You just put that on a T-shirt. All it is ornamentation. You put names on a T-shirt in big bold letters, right? It's really just ornamentation for that shirt. It's not being used as a trademark,
Mm,
okay? But
okay.
if you have their names, okay, associated with a foundation, right, that does consulting work for relatives of murdered family members, or political consulting or something like that, more in the style of Mr. Floyd's brother and how he's applying for the mark. Could you get a trademark in that? Yeah, maybe. But there are some, beware, there are some states that have laws about um, using the names of dead individuals as trademarks and basically adopting their publicity for your own purposes. Case in
Mm,
fact, um, now this name just slipped my mind. Michael Jackson. Okay,
mhm,
his estate makes a lot of money off of his name and image still, and licenses that name and image still. Uh, Tupac Shakur, his
mhm.
estate is very protective of his name and image because California has a law that does not allow you to capitalize on the names and images of deceased persons. Other
Okay.
states don't. California does. Why? Because there are a lot of famous celebrities here, right?
Right. Yeah.
So you got to be very careful about that.
Yeah. I wonder if it was an artistic way that you did it, could you trade you I mean, well, even still, that's so iffy of an area. Yeah.
If you're using their name, okay, for a commercial purpose, probably regardless of the art associated with it, you might get into trouble. I will say, there are a couple of cases where um, politicians have had their image and likeness and name put onto shirts, in an artistic manner. Why are they not being sued? Or why are those people not being sued? Because essentially now you're talking about political speech and
Mm,
free speech, and courts are loath to preclude you from having political speech, okay, as opposed to commercialized, use of somebody's image or name. That
right.
is a difference. And I know for a fact I've seen T-shirts. You know, there was a Hillary Clinton doll. There are a couple of dolls of politicians. Why are those manufacturers not getting sued? It's political speech, okay, or
Okay.
parody.
Or even I think of that hope poster for Obama that was all around everywhere.
Yeah.
You know,
So
like
there's an interesting story behind that.
oh.
So that hope poster was created by a particular individual. Okay, very cool, very unique. He subsequently got sued for copyright infringement.
Mm.
Why? Because actually, a reporter from, I believe it was the AP, took that picture and got the copyright for that picture. And the artist who subsequently colorized it, did so without the permission of the photographer who took that picture of Obama.
Yeah, now that's such a, because when I was looking up questions to ask you, I noticed that there was some like gray area there, like as long as it's 10% different or something than the original, but this is completely different. So that's why I'm like,
So
it doesn't really matter.
it's
Yeah.
not a percentage thing, okay? It is it's usually you will get in trouble if you take something and it's not changed at all, okay? Direct copying. But you can take portions of stuff, okay, sometimes put it into yours and you'll get sued for copyright infringement. Why? Because you really didn't change the fundamental um, aspect of what that was. That was a picture of Obama,
Mhm.
okay? And they really weren't changing, and which was being used for a purpose of, you know, newsworthiness, and they weren't really changing the fundamental features of that copyright, okay? And it was a question about how much is enough and how much is too much
Yeah.
or not enough. I think I was telling you there's an artist who does art out of New York, and he basically takes the pictures of other artists, okay, photographs, and he will put blotches in it, okay? And the courts, believe it or not, get into, well, okay, that photograph doesn't really look like the original photograph anymore, so that's not a copy. Whereas that one, where you can still see the person's dreadlocks and their features, and even though you've blotted out their eyes, you can still identify the original photograph in that one.
Mhm.
That one, not enough change. Okay. It's not a 10%, it's not a 15%. There are no percentages. Okay. The courts don't look at percentages. Is that direct copying of the original work, and is it you being utilized in the same fashion? Then a great example. Google has created this massive library, right? Scanned in all these books, and allows individuals to run searches through these books to capture particular words. Okay, but you can't see the whole book at one time. You can only see snippets of the book, a couple of
Mhm.
words left and right of where your word is found. The authors sued Google Library and these universities over that, okay, saying, hey, this is copyright infringement. I never gave you permission to do that. Court said, no, it's not. Why? Because the feature that you copyrighted was a book to read. This software has nothing to do with an individual reading this book. This software allows people to search for a particular word, and you can't read the entire book after you've done the search. All you know is this word is being used X number of times in this book.
Mhm.
So
Mhm.
they fundamentally transformed the use of that copyrighted work into something different. Transformative use is the term the courts use. So if you've transformed the use, don't get copyright protection anymore. Do I know what the line is for transformative use? I couldn't tell you if I had 100 years, okay? It's very gray.
Yeah,
The
okay.
courts look at it and they say, you've transformed that use, you've not transformed that use, okay? Art's one of the places they look at. I hate to think that, judges are being art critics, but essentially that's what they're being asked to do. Have you transformed that other artist's work enough so that now it's something different? That's kind of where it's headed. But it's not a percentage thing. It's no longer being used in the same way. It's being transformed into something different.
Mm. Who knew? There's so much every time that I'm like, there's so many more questions, so much more to say, but we'll have to save it for the next time because it's already 7 o'clock. Well,
4 o'clock my time, 7 o'clock your
oh,
time.
don't make me
Yep,
do math on Mondays. No, I'm kidding.
absolutely. If folks have questions, I love it. These were great questions, Camille, and as always, it's great being with you and kind of explaining this stuff.
No, it's my pleasure. I know that you're so busy because work doesn't stop for you, especially living in LA. There's
That's a
always
fact.
somebody to do. No, I'm kidding. Well, I can't tell you how much I appreciate having you on again because I always learn so much. Our conversations before to prep for this, and even more so when I get on air, where I just can't wait for our next conversation. And one question I keep forgetting to ask you is, how do you pronounce the law firm you work for?
You had it right this time. It's Kleindienst. Okay, so you got it.
Yeah, I was going to think Kleindeck Bar. So I'm like, oh wait, how do you pronounce it? Because I'm thinking of the bar.
Right. Nope. It's Kleindienst PC. We have offices all over California, as well as in Seattle.
Okay. For some reason, I thought they had a New York office as well, but just on the West Coast. Got it.
Just on the West Coast right now.
Fantastic. Well, thanks again for your help and for being a guest. Really appreciate it. There's a lot of people saying thank you as well. And one last question slipping in. The question may have already been answered, but can you add TM to your business names on social media pages while you're waiting to get your business trademarked?
So TM doesn't really do anything. You don't have to have TM. I'd be careful about having that. And again, just because you have a business name doesn't mean it's being used as a trademark. As we talked about, Kimberly Clark is a business name. Huggies is a trademark. Okay. Be very careful about that. Just using your name as a business name does not mean it's trademarked. Okay.
Okay. Got it. Well,
Awesome.
thanks again for all your great help, and I appreciate it, and I'll have you back again soon.
Thanks for having me, Camille.
You're way more informative than some, I was going to say the websites, but I don't want to get in trouble for using their trademark.
There you go. I'll talk to you again, okay?
All right. Sounds great. Thanks a lot, John.
Have a great week. Be safe.
You too. Mask on, right?
Right. Mask on.
All right. Well,
Bye.
Bye. See you soon. All right. Thanks again, everyone, for tuning in to the E-Spot with Camille. I am your host, Camille Cower. And for all of you that are joining me, actually, Rhonda reminded me on YouTube, I really appreciate it because now I'm simulcasting live. So you can catch me live, whether you're on Facebook, YouTube. So please share with your friends that may not be on Facebook so they can be aware and watch as well now live. And I really appreciate it. And on Fridays, I am now going to be live on Instagram. I wanted to make sure I was where everybody is talking to me at because I get so many conversations and I do a lot of lives on Instagram, but then some of those people aren't Facebook, so they miss out on all the e-spot, but they see all the advertisements. So I'm kind of spreading myself around, if that makes any sense. And I appreciate you guys all tuning in. Make sure you share, like, comment, and I appreciate you guys so much. We're going to have a fun week. I meant to bring my calendar up and I just realized I didn't. We're going to have a fun week. There's a lot of great artists that I'm having this week. I can't remember the order, so I'm just going to say the names. I have Amadeus coming in, who is the drummer for Trey Songz, as well as he owns his own music production company, producer, and so on. He's going to be on this week. I'm going to have, I'm very excited about this because I don't get a lot of women on, which is kind of disappointing because I'm a woman, but whatever. Shay McCrae, she has the Shay McCrae show. She's going to be my Friday guest on Instagram. She works for FUBU Radio, so I'm very excited to talk to her because I'm sure any 90s kid out there, FUBU was life. So I'm very excited talking with her. The women behind Oya Media Group, I'm having them on this week. They're out of Toronto and they have a wonderful Black female driven production company. So they're going to be on. So already 3 women in 1 week. I'm very excited about that. Trying to think who else. If I didn't say your name, it's not because Geechee Dan. He is the executive director for Hip Hop Museum out of DC. He's going to be my guest this week as well. So make sure you tune in because this week it is on and popping. I'm going to have a lot of great fun people this week. I'm very excited and I really appreciate all of you guys tuning in, commenting, liking, and sharing with your friends, your network. I really appreciate it. And don't keep me the best kept secret, right? Yeah, let everybody know there's no trademarks needed. All right. Thanks again. Have a great day, and I'll see